Berlin, Free University. Professor Calless is an expert in European law and public law, and he's currently teaching at Free University of Berlin. Professor Calless is also an legal advisor for Environmental Committee of the Prime Minister, has been the scientific advisor for the German version of Sustainable Development Commission. So he is a renowned environment law expert, and he has also authored an important paper about the rule of law and environmental state. So it's a great honor to have him here for this conference. Professor Calless, please start your presentation. We can give you 30 minutes.
Thank you very much for the invitation. It's an honor to speak to you, and I will try to give you an introduction now in aspects of environmental protection through constitutional law in Germany and the European Union. Ladies and gentlemen, environmental and climate protection is driving the political agenda in Germany and the European Union despite the corona crisis. Influenced by the Fridays for Futures movement and the results of the European elections last year, the political debate has flared up, during which many well-known proposals discussed over the last 3 decades already are on the political agenda again. These include, for example, elements of the European Green Deal proposed by the European Commission, or the debate we already currently have in Germany about anchoring climate protection or sustainability in the German Constitution. 3 questions arise in this respect. Why is an effective environmental protection policy so urgently needed? How can we move beyond non-binding plans and strategies that are worn down in everyday politics? And what role does constitutional law play in this context? First of all, why is an effective environmental protection policy so urgently needed? I would like to draw your attention to this slide. It is about planetary boundaries. This term, first of all, refers to the undoubted biophysical limitations of the Earth with regard to the availability of natural resources and the absorption capacity of things. It is true that ecosystems can compensate for impairments to a certain extent. However, above a certain load level, disturbances and ultimately irreversible damage occurs. The core concern of the concept of planetary boundaries is to provide for a safe operating space for humanity, in which is highly likely to meet stable conditions of the air system. In this respect, Earth system science refers to tipping points. And what this slide shows, this is, you have here the soil and you have ice on a lake. And we all experience this. The closer you come to the center of the lake, the thinner becomes the ice, and then it may crack already. And this cracking is a tipping point. And if you're on a tipping point, it might happen that you the ice breaks and you fall into the water. This is described by this picture, and we are not already, or we are closer to tipping points, especially with regard to climate protection. In climate protection, a tipping point is this This protection target agrees in the Paris Convention, which calls for limiting human-induced global warming to well below 2 degrees Celsius compared with pre-industrial values, if possible, to 1.5 degrees. You all know this. These represent a planetary boundary based on inside of Earth's sign system. The problem is, and now I come to the German sustainability strategy, that we are successful in strategies, non-binding strategies, political strategies, and plans when it comes to environmental protection or climate protection. And you can see this. Germany has a very ambitious sustainability strategy for 2030. But if you look at this, at the environmental goals, you see there's a lot of red and orange and only a few green fields. So this means that most of our goals in the German sustainability strategy, we fail in this regard. And the question is, why is that so? It has to do with the fact that these political strategies are not binding. Therefore, it is very important to transform them in legislation. And this is what constitutional law enables. First of all, I want to have a short look, before we come to the Constitution, on state theory. And there, in this regard, it is important to know and to keep in mind that the compliance with planetary limits must be understood as a concern of the entire global community. The concept of planetary boundaries gives rise to an urgent mandate for action, which gives the transboundary nature of many environmental problems can often only be fulfilled through international cooperation. And this international cooperation needs states, the international community of states, to work together in the form of international cooperation, in the form of international treaties. Already we have a lot of international treaties, especially with regard to climate protection. In the Paris Agreement, we agreed even on the planetary boundaries, to the 2 degrees goal. But we have to deliver. And in this regard, state theory shows us why all states, independent of their institution, are, from state theory, expected to deliver. Because, according to state theory, due to the monopoly on the use of thought of the state alone has a responsibility to guarantee security. And therefore, the state received appropriate means of power to protect its citizens. With state powers being limited by the rule of law at the end of the 18th and 19th centuries, and the democratic and liberal constitutional state was created, the 19th and 20th centuries saw the emergence of the steering, performing and distributing welfare state, the Sozialstaat in Germany. And today we see the emergence of a new kind of state, the environmental state, which is responsible or takes over the responsibility for the protection of the environment, of the environment. This means the protection of the environment is part of the old traditional purpose of safeguarding public security. The role as based on its monopoly of force, this is state theory, it is only the state that can define environmental protection measures in a way that is binding for all social actors, and if necessary, the state is the only, or public authorities have the power to enforce this environmental legislation. So, If we look at this, security, environmental damage threatens individual legal rights such as life, physical integrity, or property. And exceeding the tipping points is likely to lead to economic and political destabilization of the state. So the state has a responsibility to deliver concerning the state responsibility on security in a broader sense. I come now to the German Constitution. However, environmental protection as a state responsibility is not only based on state theory, but it's also anchored in constitutional law. Article 20 of the German Grundgesetz, 20a of the German Grundgesetz reads like this. I have it here on my presentation on this slide. And it is not, and this is important, it does not establish an individual and fundamental right, but only a state objective that appeals to all state authorities. Article 20a was inserted into the Basic Law in 1994 in the context of German reunification. But after a long debate in academia, one could only agree on a state objective, but not on an individual fundamental right to a clean environment. In general, state objectives do not entail an individual right, but conditionally determined rules according to the if-then scheme. They entail only final objectives which are to be fulfilled as far as possible as optimization imperatives in consideration of conflicting objectives. For this reason, they do not establish any individual right, but the legislature, the parliament, must concretize the state objective by simple law, taking into account conflicting constitutional concerns. Conflicts between different constitutional objectives in this legal framework must be resolved by means of proportionality, weighing and weighting the corresponding interests. The Federal Constitutional Court can, in principle, review whether the legislator fulfills its duty to concretize and realize the state objective. However, the political decision-making process must not be shifted to the courts and thus removed from Parliament. The justiciability of state objectives is therefore limited to evident misconduct on the part of the legislator, which misinterprets, for example, a state objective, ignores it, or does not even attempt to implement. So if there's no legislation, then we have an infringement of a state objective. In this regard, the Untermaßverbot, a kind of undersize ban, defines the minimum of protection. An effective and coherent protection concept is required by the legislator. I will come back to this later. When we now take a closer look on this state objective, we see that the reference to future generations in Article 20a has proved to be a decisive point of reference for the specification of the level of protection. From the explicit obligation to protect the natural basis of life, also for people living in the future, follows the material obligation to consider even ecological consequences of today's action, which lie then far in the future. So the current legislation has to include the interest of future generations as a yardstick for action, which is an element of sustainability. This is intergenerational equity. This implies a duty to protect and furthermore a duty to prevent serious and irreversible environmental degradation. This coincides with the risk-based approach of the precautionary principle, but means a lack of complete scientific certainty must not be a reason for postponing cost-effective prevention measures in the event of imminent, serious, or irreversible danger. The precautionary principle aims at efficient risk management, as you know. Intervention of public authorities can be shifted forward in the area of risk. This means before a hazard, defined as a sufficient probability of damage, can be proven. Forecasts of future developments are sometimes subject to considerable uncertainties due to the dynamics of the development, the multitude of influencing factors and ecological interactions. According to Article 20A, the precautionary principle is a guiding principle under environmental law with constitutional content. And in European law, it has been expressly standardized as a legal principle in concretizing the Union's objective of environmental protection. So in Germany and the European Union, we have the precautionary principle as a guiding principle for environmental protection law. The precautionary principle allows for government action under the condition of uncertainty in order to act in an early stage on the basis of identified potential risks to avoid harmful effects as far as possible. A classic expression, as mentioned, is of the precautionary principle is risk management. The use of many technologies is associated with uncertainty regarding their ecological consequences, which make it necessary for state powers of intervention to be shifted forward into the area of risk. If we have a final look on the precautionary principle, this coincides with the planetary boundaries and the tipping point. In view of the protection mandate of Article 20A and the resulting precautionary principle, the safe operating space defined by planetary boundaries and the tipping point must be observed with binding effect for all legislation. In a German sustainability strategy of 2016, the federal German government therefore aptly described the planetary boundaries as the absolute guardrails for political decisions. Now, of course, it's time to deliver, but this is already acknowledged in the sustainability strategy of Germany. So now we come to fundamental rights. As I already mentioned, it is true that the basic law does not recognize a fundamental right to environmental protection. The main problem, and this is agreed by academia, is to determine the scope of protection of such a fundamental right. But German German academia and by the German Constitutional Court, there was developed an approach to interpret fundamental rights, not only as a duty to respect fundamental rights by state authorities, but as well by interpret fundamental rights by a duty to protect. This is a second dimension of fundamental rights. And we as well interpreted fundamental rights to entail three building blocks, three elements of a procedural fundamental right to a clean environment. These are the right to participation of the citizen in environmental the relevant decisions of their administrations, the right to adequate access to justice, to control political decisions on the environment, and as a necessary precondition for the exercise of the two other rights, a right to environmental free information. Also information, participation, access to justice. These are the three elements of a fundamental right to a clean environment. These elements are confirmed by the United Nations Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, the so-called Aarhus Convention, which was implemented by European Union law and German legislation. However, neither the German Basic Law nor the Charter of Fundamental Rights of the European Union do contain explicitly such a procedural right. This is does just exist in German in legislation, but parts of this, at least in German doctrine, according to German doctrine, form part of certain fundamental rights I would like now to talk about. If we look in the German Constitution, we see Article 1 of the Basic Law, which is human dignity, that is interpreted by doctrine in conjunction with Article 20a as a guarantee to an ecological minimum standard of living. That it protects against massive environmental destruction. If there's a threat of irreversible environmental damage, if the tipping points, for example, are exceeded, which could result in a kind of devastation scenario, then, from a legal perspective, the right of every citizen to the ecological subsistence level, let's call it like this, is the translation of the German word ökologisches Existenzminimum, is infringed. In the basic rights to environmental protection is Article 2, Paragraph 2 of the German Constitution, the right to health and the right to life. Regarding this right, the Constitutional Court especially developed its jurisdiction on the duty to protect. This is called Schutzpflichten in German doctrine. Schutzpflichten, the duty to protect of state authorities, to protect health and life against environmental pollution, which is normally rooted by private action, companies, private people, car drivers, whatever. So it's normally that the state has to act by legislation to protect health and life by legislation. The decisive question in this regard is what is the content of this duty to protect? On the one hand, the Constitutional Court, in accordance with the state objective of Article 20a, agrees that the precautionary principle is part of this duty to protect. Environmental damage and resource shortages must be counteracted at an early stage. In this respect, a scientifically founded initial suspicion is sufficient. No scientific proof is required. Moreover, the question is, how can the fundamental right, the duty to protect, the status positivus, as it is called, as well as you see on this slide. Here I repeat again about the from the duty to respect, the status negativus from fundamental rights, that leads to the fundamental rights having a protective dimension, the duty to protect. And important with regard to the German Federal Constitutional Court is the judicial control of the parliament, of the legislator. And in this regard, we have a dispute in Germany. because the standard of control in the jurisdiction of the court is not a coherent one. Let's say it like this. This has something to do with democracy, with the respect of the Constitutional Court regarding the three branches, with the respect of the Constitutional Court, the judiciary, with respect to the parliament. The former president of the Federal Constitutional Court described the Constitution as a framework for the implementation of the state objective of environmental protection, which, due to the complexity of the matter, was to be filled first and foremost by political decision of the democratically legitimate legislator. However, I would say it is problematic in this respect that the Federal Constitutional Court does not apply a uniform control standard for the infringement of the duty to protect. If it restricts itself to the so-called evidence control, a violation of the duty to protect only exists if the public authority, the legislator, the parliament does not take any protections, does nothing at all, or if the measures or regulations taken are obviously, evidently, completely unsuitable or insufficient to achieve the protection objective. But the Constitutional Court in other cases had a stricter standard, control standard. It requires, this is the so-called Untermaßverbot, the ban on undersizing, this is a translation. In other cases, this requires adequate and effective protection, which must also be based on careful fact-finding and reasonable assessment. So this is a stricter standard of control because it is stricter than a mere evidence. The Constitutional Court in this, under this control standard, expects the parliament, the legislator, to deliver a coherent and efficient concept of protection by legislation. This is something different from this control, from the so-called evidence control. And therefore, it would be very convincing if the Constitutional Court is going to apply constantly, in a coherent manner, the ban on undersizing, the so-called Untermaßverbot, when it comes to the duty to respect. Now, to conclude, I come to the requirements under European Union law. First of all, it's important to know that European environmental law takes precedence over national law. It's a so-called primacy of European Union law. And there we have two very important, much more concrete than the German constitution with Article 20a, objective requirements on environmental protection. First of all, it is Article 11, which is, from my point of view, a very important procedural approach to environmental policy. Environmental protection requirements must be integrated into the definition and implementation of the Union policies and activities, in particular with a view to promoting sustainable development. What does it mean? It does mean that the environmental needs defined in Article 191, the objective of the European Union, of the European Union, that these must be integrated into all other policies, which means traffic policy, agricultural policy, and so on. And Article 191, you can see, I already mentioned this, that together with this cross-cutting clause of Article 11 transports the environmental needs, the environmental objectives and principles into all other policies. Let it be agricultural policy, traffic policy, industry policy. So at least from the legal framework, this is the basis for the European Green Deal. And you see in Article 191 that the precautionary, European environmental policy, here if you look into paragraph 1, Union policy on the environment shall aim at a high level of protection, taking into account the diversity of situations in the various regions of the Union. It shall be based on the precautionary principle and on the principles that preventive actions should be taken, that environmental damage should be a priority, be rectified at source, and that the polluter should pay. So the 4 principles, general basic principles of environmental policy, are explicitly part of European constitutional law, treaty law on the environment. I come now to my conclusion. In particular, the planetary boundaries, with their concept of a safe operating space, the climate protection target agreed in the Paris Convention I mentioned already, which call for limiting human-induced global warming to well below 2 degrees Celsius compared with pre-industrial values, if possible, to 1.5 degrees. These planetary boundaries correspond to the state objective of environmental protection in Article 28 of the Basic Law and the precautionary and its inherent precautionary and sustainable principle. You remember this interpretation of the reference of Article 28 to future generations. Essential normative guidelines for dealing with planetary boundaries follow from the precautionary principle. Both dimensions of the precautionary principle, risk and resource precaution, aim to avoid critical loads or tipping points which is reached could cause serious and irreparable damage to environmental assets. The precautionary principle entails the principle of non-exhaustion of planetary boundaries. The closer planetary boundaries are from being exceeded, the more weight must be attached to the environmental requirements and political considerations. If there is a threat of irreversible environmental damage, if tipping points are exceeded, or are close to being exceeded, let's say it like this, which could result in a kind of devastation scenario, then from a legal perspective, to the right of every citizen to the ecological subsistence level, which is based on human dignity and the fundamental right to life and health, which is Article 1, Article 2 of the German Constitution, and based on the state objective 20a, is infringed. The ban on undersiding, the Untermaßverbot, developed in German doctrine and developed by the German Constitutional Court, requires a suitable and effective protection concept in the context of the state future and long-term responsibility flowing from Article 28 of the Basic Law and from European Union law, the mentioned Article 191 and 11. In this regard, it's very important, especially regarding the European Green Deal, to be aware that European Union law is implemented by the member states as a rule, and the German public authorities in implementing European legislation, for example, stemming from the European Green Deal, are bound by the provisions of Article 11 and 191, in addition to the German constitutional principles. It's a kind of environmental multi-level constitutionalism. The European level, the European treaties with Article 191 and the German constitution, they are closely interlinked in this regard. As a result, the constitutionally recognized ban on undersiding, the Untermaßverbot, thus requires that the safe operating space defined by planetary boundaries is prevented from being exceeded by a suitable and effective, long-term, coherent, and legally binding environmental protection concept. This is exactly what the Constitutional Court, the German Constitutional Court, could control based on the German constitutions on the fundamental rights on the one hand and the state objective on the other. In view of the weak enforcement of environmental and climate protection issues in everyday political life today, even in the case of adopted government strategies, additional consideration, and this is very important, must be given to climate protection through procedure. With regard to a fundamental right protection, this means that the right to information, the right to participate in decision-making processes, and the duty and the access to justice, these three elements of a procedural fundamental right to a clean environment must be observed in legislation. And they are already, but they have to now to develop, especially in German law, they have to be developed further. I think Roda Verheyen will talk about this a little bit more when it comes to the procedures regarding climate protection at the Constitutional Court. And ladies and gentlemen, in this regard, this procedural aspect is important as in more concrete terms as well with regard to the political process. It's important to establish a monitoring in the political decision-making process so that politics deliver on the agreed strategies of sustainability and climate protection. In Germany and on the European Union level, in Germany we already have now, and this is a big leap forward, we have now a climate protection law, and we will have one on the European level. And by this, the approach with regard to planetary boundaries, the Paris Agreement, the 2 degrees, 1.5 degrees planetary boundary, is now put in a more binding legal framework. But this framework has to be monitored now in the political decision-making process, because the agriculture policy, traffic policy, construction policy, all these sectors have to deliver, and this has to be controlled, that the legislation decided in these areas by the parliament, that this is in conformity and is coherent with the climate law as that establishes this suitable and effective long-term coherent and legally binding environmental protection concept. Yeah. The challenge we face right now, especially in Germany, is how can we improve our implementation, our management of the decided political legislation. Thank you very much.
네, 대단히 감사합니다.
Thank you very much, Professor Calless. Thank you for your presentation. This is a very complicated concept for us to understand, the constitutional law of Germany. I know it must have been challenging for you to express that in English, and fortunately, it is in line with the behavior and attitudes of the Constitutional Court of Korea, and I believe the participants here had no problem understanding your objective and presentations. As Professor Wood has mentioned, she has asked stronger and more active roles to the court, and Professor Calless is saying that legislation and politics should play more active role, and Constitution is like providing the boundaries, and Germany, they do not have environmental rights. It is mentioned as a state objective. In spite of that, what kind of functions can Constitution play? And Professor Calless has given us various examples. Even though there is no environmental rights, German basic law has human rights, and the state has the duty to protect such fundamental rights and the ecological subsistence level can be mandated. And as a basic building block, there should be a ban on undersizing. And we'll talk about this later, but how much undersizing is tolerated? So there could be different level of undersizing tolerated here. In the United States, when it comes to climate issues, they're trying to ignore this issue, while the European countries like Germany are actually taking actions. But what is the level of satisfaction of these actions? And then, regarding the principle of environmental protection, there are things that need to be considered for the environment, or above that, there are something the government should actively engage in for the protection of ecological subsistence. So at certain level, the Constitution can ask for the strong action and interference from the state. And there will be more discussion later on. Now, we are going to move on to the third presentation.
변호사님의 발제.
So we'll invite lawyer Roda Verheyen. Lawyer Verheyen resides in Hamburg and is an expert in climate change and environment, and also environmental activist. And climate justice program, network climate justice program was created by lawyer Roda and is worldwide known. She will be introducing numerous cases, and actually she's the one who handled these cases. So you'll be able to hear the first-hand experience, especially the climate change litigation. You'll be able to hear the direct experiences from the lawyer. I'm sure that her presentation will be very helpful, especially she already, as you know, received a PhD degree, and there are papers about the climate justice and climate change. So from the legal perspective, she will give us a great presentation. So could you please start?
Yes, good morning. Can you see and hear me?
네.
Okay. So hello, good afternoon. It's morning here, blue sky in Hamburg. It's a great honor to be asked to present at this very distinguished conference. As you see, I will try and relay some examples of climate change litigation in Germany. I can draw greatly on Professor Calless' presentation because he essentially introduced all the concepts that are also featuring in my cases. So thank you very much, Professor Calless, for that. I will try to give you a practitioner's glimpse and try to skip over the things that you might have already heard from Mary Wood as well. I'm a legal practitioner in a private law firm. If I am called an activist, it's probably because we as lawyers are also biased, and we do have an opinion, and so do I, but I am actually just a lawyer. So what I will speak about today is climate change and the role of courts so far, and we've already heard some of that from Mary Wood. I will talk about the role of the famous gender judgment from the Netherlands, and I will talk about the German case experiences. I've picked two cases. I will give you a glimpse of some others, but I will mainly talk about two cases that are actually in administrative and constitutional courts here in Germany, and then I will give you an outlook from my perspective as a practitioner. So, and I will try and speak slowly because I have not actually presented a full manuscript, so I will try and be cognizant of the translator. So you have already heard about the problems that we are actually facing from Mary Wood. In 2018, the IPCC has said that we could still save millions of lives and ecosystems if we actually try to keep within the 1.5 to 2 degrees temperature targets. However, in 2020, and despite COVID-19, global emission trends keep rising, and this year has again been the hottest yet, with all the terrible impacts that we can see and that my clients are already experiencing today. So we are not, from my perspective, talking about the role of human rights in the future, but we're talking about infringements and actual implications for human rights and the enjoyment of fundamental rights today. So climate change and the role of courts. First of all, it is necessary to note that the existence and legal relevance of anthropogenic climate change, so the human signal in climate change, has been confirmed by courts all over the world. We have heard from Mary Wood how the courts in the States are currently dealing with this issue, but we have very, very high-level statements that climate change is here and we are causing it. The Massachusetts EPA case was already mentioned. It is the first one where such a high court actually recognized the problem as an existing one, contrary to what some of the politicians keep saying, not only in the United States. This is a physical phenomenon that we cannot talk away. We have the 3 judgments from Ogenda in the Netherlands, which I will talk about in more detail later. We have the Pakistan cases, we have the OCT cases in the USA that Mary Wood was talking about. We have the extremely advanced judgment of the Supreme Court of Columbia from 2018. We have several judgments from the UK, not least the one that essentially cassated the building allowance for the Heathrow landing strip in February 2020. We have my case from the Administrative Court of Berlin in 2019, which clearly recognized climate change. And we have the Irish Supreme Court, which recognized it. And there's so many others that I cannot even list them all. We have UN rights bodies, human rights bodies, and several courts say climate change is a human rights issue. As Mary Wood rightly pointed out, that is not in dispute anymore. And I would say it shouldn't be and shouldn't have been for years, but I think now we can safely say this is recognized in so many courts that it really shouldn't be disputable anymore. And also we have so many constitutional and public law cases invoking human rights and a duty to protect, and they're ongoing. There is the case in the EU that I take that I won't talk about today. We have the German case that I will talk about. We have the Swiss ladies case, which you might have heard about from Switzerland, which has failed in 2 instances in Switzerland and is now probably going to the Human Rights Court in Strasbourg. We have the French case, the Canadian cases, and now we also have Korea. So the courts are in the midst of it. And Mary Wood rightly asks the court to take an active role. However, there are very limited civil courts, even though civil courts, in my view, could play a large role in protecting rights. Because what is civil law? Civil law essentially balances rights against each other. I'm sorry, I'm trying to get rid of this here. There. There are very few cases. One of the first very spectacular cases on the civil law plane was the Kivalina against Exxon case, which was filed in 2008, so very early on, which was dismissed. And I should say, due to very similar reasons to the one that Mary Wood just explained to you. It was basically a justiciability issue. We have the Coma versus Murphy case filed in 2009, which was about the impacts of Hurricane Katrina. We have several nuisance and tort cases in the US for protection costs, which are brought by communities. We have my case here in Germany, which is against the major energy utility. My client's name is Luciano Julia, he is from Peru. And we have a new wave of cases which are calling on not governments, but actual private entities, here Royal Dutch Shell, to actually change their ways and to fulfill their duty of care and to protect. This was filed in 2019 and actually asks Royal Dutch Shell as an oil company to phase out fossil fuels by 2050. This is the Kivalina village. It is now essentially displaced and the area is flooded. This case was about permafrost. The courts could have changed its fate. It might have been too early. There is no longer any scientific question about whether or not this village is gone due to climate change. This is in the Arctic. But we have seen a historic win on the civil law plane, in my case in Germany, and I was asked to talk very briefly about this. So even though this has nothing to do with the duty to protect on a constitutional level, it is important to see that the civil law is actually able to attribute responsibility. So essentially, there is an application to bear costs to cover the expenses for safety precautions to avoid damage to my client's property from a glacial outburst flood. There's many videos on YouTube about this case. You'll be able to access it. There's also several films. We lost on first instance in 2016, but on appeal, the High Court in Hamm actually decided positively on legal issues. There is legal causation. Even if it's only partial or contributory causation, the responsibility might be sufficient. It is possible that this one entity in Germany contributes to climate change and the flood risk that is posed to my client's property in a significant way. And generally, there's responsibility of large emitters. And that's why I call this a historic win. The case is not terminated because we've been ordered to enter the evidentiary phase with 2 more legally confirming orders in 2018, and we're awaiting a site visit, which is not getting easier with COVID-19. So again, the courts are in the middle of climate change. They have a role to play, and they will need to play it. So what have the courts in the Netherlands done? Agenda shows that judicial intervention can be a success. We have 3 judgments spanning from 2015 to 2019, which say essentially the following. Climate protection is justiciable. It's not a matter of political discretion, which is essentially what Mary Wood talked about. There is the duty to protect. The state cannot arbitrarily choose targets or programs, and this is based on the European Convention on Human Rights. Climate science can, on the basis of international law and consensus, define the state's duty to protect, because what Professor Calless said, of course, is correct. What we struggle with today in academia and practice is, what does that actually mean? What is the state's duty to protect? Each state, that's the answer of the Supreme Court of the Netherlands, must do its share. Even if other states do little and international environmental law is insufficient, human rights principles create objective obligations of states. That's extremely important, and that is one of the issues that we rely on in our constitutional complaint, both in Korea and in Germany. The courts could take this stance in every jurisdiction. That is my view. And you can see that that's also the minority view in the US, what we just heard this morning. The major difference from most other cases is, to my mind, is that Agenda had no problem of standing. This might not be the main difference with respect to the Juliana cases, however, I do think that that also plays a role. The Dutch civil law statutes actually include an explicit right of associations to make claims for everybody, for the whole community. For society as a whole. And that is non-existent in most other jurisdictions of the world, including Germany. So let me move on to talk about my cases in Germany. I will first speak about a court case that we took to the administrative court in Berlin, and then about the ongoing constitutional complaint. So the first German climate action at the administrative court level had as plaintiffs 3 farmer families, including the children of those farmers, and Greenpeace Germany as an environmental association. The subject of this lawsuit was only and solely the enforcement of the German Climate Change Program 2014, with the target of reducing CO2 by 40% by 2020 compared to 1990. So we did not ask for further targets or for 2030 targets or a recovery program. We only asked for the German government to do what it had been saying for almost 15 years to fulfill its own target. And the legal issues in this case was mainly, and for the first time in German history, the question of whether climate protection is actually justiciable. And the same issues that were raised, that Mary Wood was talking about, by the US judiciary was raised in this case. The defense by the German government relied solely and only on saying that actually the issue is not justiciable. It is solely in the margin of discretion or even full discretion of the administrative and legislature. There is no way the courts could have any say in how people and the planet are protected. The other issue was, of course, is climate change a human right? Can you defer, as Professor Calless just explained to you, from the German Constitution together with European law and the European Convention on Human Rights, a right to some sort of safe climate? And is the duty to protect that Professor Calless also explained to you from the German Constitution, is it applicable here given the complex situation? The rights we argued in this case was only vocation and property, because we felt that in this case that would actually already suffice, and there is a duty to protect based on Article 2 of the German Constitution as well, but including Article 12, which is vocational freedom, and Article 14, which is the protection of property. I will remind you, this is 3 active farming families. They were actually arguing the protection of their land. So this is the actual lawsuit, just a little glimpse of what it looked like. And what happened? The hearing and judgment took place in October 2019. We were granted an oral hearing, even though standing was a major issue. What we heard and discussed in the oral hearing was climate protection is justiciable. The court had no problem explaining that, of course, government could not choose whether or not it wanted to protect the environment and the climate. As everything else under the rule of law, the activities and omissions of government are under scrutiny by the courts. That's an extremely important statement and is now used also in the Korean lawsuit, as far as I know. The climate target is not law, therefore the plaintiffs cannot enforce it. That's what we argued. But plaintiffs can ask the government to perform its duty of care based on the German Constitution, the principles of which Professor Calless just explained to you. Climate change can and does impact plaintiffs' human rights, but there is a large margin of discretion. As again, Professor Calless pointed out, how do you deal? What is the Untermaß? How do you actually specify each state's duty of care? And then finally, the current performance of the government in reducing emissions does not infringe the duty yet, especially with the new climate law. And I have to say that I added the yet here because that does not feature in the written opinion, but the court said the word yet several times during delivering the oral judgment. And what you see here on the picture is us and me standing there in front of the media. You can see that this case raised a lot of questions in the public and also in the public outside. So let me turn to the constitutional complaint. We were given leeway to appeal the judgment, which essentially dismissed our claim in the Berlin court. However, it was impossible for us to actually make use of that appeal because of the Climate Change Act of December 2019, which came into force only a month and a half after our judgment was rendered by the Verwaltungsgericht in Berlin, so the administrative court. That changed the procedural elements of the whole case, and we could not, it wouldn't have made any sense to go to appeal. So what happened is that many of the youth included in the former case in Berlin, plus some others, decided to take a constitutional complaint against the Climate Change Act itself, based on these rights that I set out here, Article 1, human dignity, Article 2, health and life, Article 12, vocational rights, Article 14, property rights, all in conjunction with Article 20A of our basic law, which has just been introduced to you by Professor Calless. This constitutional complaint is essentially what Professor Calless just talked about. It is about defining the duty of the legislator to protect. It is saying that the current climate law does not actually constitute a discharge of the duty to protect on the basis of the Untermaßverbot. These are the plaintiffs here. They're all in different capacities affected already, and of course their whole generation is affected, as we heard from Mary Wood this morning. So the arguments in the complaint are the following. The new Climate Change Act does not pursue and define an adequate level of protection. Professor Calless used the word of ecological subsistence or minimum level of subsistence. We're saying that the reduction pathway is not compatible with protecting human rights, and particularly does not even attempt to limit warming to 1.5 degrees. I should turn back to my first slide and also Professor Calless' explanation of the tipping points. What we're arguing in this complaint is that we are slowly losing control, and there is an absolute need to regain control. This is what you already heard from Mary Wood as well. So essentially, we're saying this pathway, long-term pathway, is not credible. Against the backdrop of climate science and the real possibility of losing all control over the climate system, again, the tipping points, the duty to protect translates into doing what is possible. Everything that's possible has to be done now to regain control. If not, the young plaintiff's rights to self-determination in the future is so limited that human dignity is threatened. This is exactly what Mary Wood's academic writings have said for, I would say, probably 3 decades. There is simply no way that human decision-making is possible if tipping points are reached. Human rights are already affected today. I said that already. This case is not about the future only. It is about today. So not only when 1.5 or 2 degrees global temperature rise is reached will human rights be affected. They are affected today. We see far-reaching impacts on those plaintiffs and obviously many other people around the world. We have this issue of standing. We can talk about that more, but in both the administrative law case and this constitutional law case, we must show that these plaintiffs somehow can be differentiated from everybody else. They have to be concerned directly, currently, and in themselves, in their own rights, in their basic rights, by the challenged inadequate statutory provisions or the omission. And this is one of the issues that will probably gain some traction in the opinions that we are expecting from government now. The issue being, there is no right of any association to take this case in Germany. There is the only way to enforce human rights in Germany, or rights at all of protection in Germany, is if people argue their own subjective rights in front of the courts. But at the same time, because climate change affects all, it is very difficult to show why exactly those people should have standing. And that is also why there are so few cases by the Constitutional Court yet that actually define the duty of care and the duty to protect in the context of environment. Because logically, if you take environmental cases, there will always be a very large number of people affected. So this is the actual demands in my claim. So the claim is about violations of basic rights, as I said before, and when you turn to little 1, you see what we're actually asking the court to do. We're asking the court to declare that the 55 reduction quota in the climate change law is insufficient. It is insufficient because it does not grant a logical and scientifically robust pathway. And we also ask, this is little 2, to declare that the legislature is obliged to ensure, within a period of time to be set by the court, by means of a new statutory regulation, that greenhouse gas emissions are kept as low as possible on the basis of more comprehensible forecasts and taking into account the principle of proportionality. Going back again to the margin of discretion and the issue of the separation of powers, we're not asking the Constitutional Court to make a declaration on what is the exact pathway or what is the exact reduction quota, because I believe that that would not be possible to be granted by the court. And I would like to just draw your attention to this for a second, even though it might be difficult to understand, and I only notice now that the actual graph has German connotations. I will try and explain it. This is the attempt to define the duty of care, because that's what we have to do as practitioners in a lawsuit like that. I have to make very clear to the court what I think is right or lawful rather than unlawful. So we view that the duty of care that exists on the basis of Article 1 and 2 and 20A of the Basic Law, as just discussed by Professor Calless, is only discharged if the legislator adopts and follows a reduction pathway in line with IPCC scenarios, so science, to at least try to do its fair share, agenda, to limit temperature rise to 1.5 to 2 degrees. And if you look at this graph, the little blue line shows our emissions to date in Germany. The red line, which has Ziele der Bundesregierung at the outset, so the right red line shows what the government is trying to do. And the dotted line is what could happen with some uncertain technology. And the global 1.5 degree course, according to IPCC, that is approximately what the government would actually have to do to discharge its duty of care. The current pathway entirely ignores the physical realities of climate change. And this graph, to some degree, is also included in the Korean complaint. Because what happens here is that government sets targets somewhere along the line and essentially ignores the carbon budget, ignores that there's only very limited CO2 amounts that we can still discharge, ignores that there is science out there that actually shows that what needs to be done to at least try to avoid tipping points and to lose control. So this is my definition of the duty of care. I do not know whether the Constitutional Court will be willing to actually engage with this, but I believe that as practitioners, we have to do this. We have to try and give the courts the potential to concretize the duty to protect. Because what happens from now on, in my view, depends not only on governments, it does depend on courts. We have reached a stage where only very drastic frameworks of actual reductions can make it so that the current and future generations remain in control. So, to finish, an outlook from a practitioner's perspective. Human rights-based climate litigation is increasing. It will increase as long as governments do not actually adopt credible pathways of reduction. The window of opportunity to prevent catastrophe is very small, and you've heard and seen the pictures from Mary Wood this morning. This is and will be increasingly recognized by the courts. And I can tell you that when I sat in the administrative court in Berlin, I could feel that at least those judges really wished they could have granted me relief. And I am determined to keep going until the time is ripe, and maybe the constitutional complaint is what it is. The issue in a human rights case is now not whether there is a duty of care. I said this before, but what exactly this duty is. Percentages by when, what is the reduction pathway, what is each country's share. And the margin of discretion in defining the duty of care is a challenge for most ongoing cases. And I think there is a real role for science and academia in law and other sciences, climate sciences here, to further determine the duty of care for each state. Because to be honest, the Paris Agreement is not going to do it. It is not going to define what each country's share is in a sufficient timeline for us to actually still act. And the last one, real impacts mean real people. A regulatory response will be needed rather than individual cases. That's clear, because my clients are only very few of hundreds of thousands, potentially millions. And especially given the standing issue, again, as I said, in most jurisdictions, you will find that there is a real problem to even enter the court doors. There is a regulatory response, and thus, of course, a role for the legislator still there. And I think that would be my presentation for now. I'm not sure whether I've actually kept within my time limit, but I'm happy to take questions. Thank you.
네.
Thank you very much. So she has talked about the controversial points in the litigations that took place in Germany and so on. It was very helpful. You could almost say that a lawyer, Yoon Se-jong, who is a discussant today, is now carrying out a constitutional litigation in Korea. So I think he's learning a lot of lessons today. So let us engage in a dialogue together. And then I think we have about 30 minutes for discussions at maximum. And Professor Park Si-won has already spoken. We have 3 designated discussants, so we would like to hear from the discussants, receive questions from the floor, and last but not least, get the comments from Professor Calless and lawyer Verheyen. Can you show us the PowerPoint slides now? As you can see, well, for the 2 foreign speakers, we are sharing this slide, and this is the environmental rights clause in Korean Constitution. All citizens shall have the right to a health and pleasant environment. The state and all citizens shall endeavor to protect the environment. The goal of today's seminar is how to evaluate and improve these areas. Next. This is how the discussion would proceed. We would like to talk about 4 major questions. So we have just introduced the constitutional element of environmental rights in Korea, but based on the assumption that this could be revised, we could have a discussion. And then, what is the relationship between human rights and environmental protection? And the third question that we could delve into would be, in climate change litigations, how much role can the courts play? Last but not least, there are many environmental issues around the world. We won't have time to go over all of them, but things like Green Deal. I think Korea and the EU shares a lot of common problems, so if there is time, we can briefly talk about that. Now, from Gyeongbuk University, we have Professor Chun-hoon. Professor Chun-hoon has studied in France, has received his doctorate degree in France, so it's a different perspective. Professor Chun-hoon. Good afternoon. I'm Professor Chun-hoon from Gyeongbuk University. I have studied in France, and I have included an article about revision of French Constitution in the book, and for translation. Let me briefly go over my article.
우리 국내에 계신 분들은 120페이지 부분을
Please refer to page 120. There are two things that I would like to talk about. First is about the amendment of French Constitution. In 2019, August 29th, the draft of French constitutional revision has been submitted to the parliament. And one of the revisions was about the environmental rights. As you are well aware, in 2005, there has been an amendment of constitution in France. An environmental chart has been inserted in the constitutional preamble of France. Among European countries, France is kind of late in adopting environmental law, but in the 1980s, France has speeded up its legislative process for environmental rights, and the cause of that would be, as Professor Calless has said, would be the impact of the European law. And in the preamble of the Constitution, the Environmental Charter talks about the environmental value, and through the Constitutional Court's decision and Conseil d'Etat's decision, they have now been assessed to have some normative values. And in 2019, a new draft of constitutional amendment was submitted. In Article 1 of Constitutions, it says that France can make supports for climate change. And at first it said it was a mandatory obligation, but in the process of amendment, the government they have to get the consultation from Conseil d'Etat, and in this process, acts was replaced with support. So agir has been replaced with favoriser. So in the environmental law community in France, in spite of the 15 years of passage, they're saying that French Constitution has actually taken backward steps. And Paris Climate Accord was signed, and a lot of environment-related summit meetings took place in Paris. But in spite of that, in Article 1 of French Constitution, I don't know all the details, but it has become something similar to the German Constitution. So even though environmental rights are accommodated in Constitution, when it comes to the details, as the speakers have mentioned, judicial decision should be made to concretize or realize the rights. And personally, so when we compare the French situation with the German situation, I don't think they're quite different. But when we look at the overall flow and context of European environment law, I think both Germany and France are not making much stride. So can we see this as a phenomenon or trend? That's my question or comment. The second thing I would like to mention is that, as many speakers have talked about, precautionary principle in France, Conseil d'État has said that along with the normative power of the Constitution, the environmental charters are always mentioned. And whether they are realized through Constitution or not, but in positive law, in the case of France, in the environmental code, they have the procedural descriptions, and they also have the democratic environmental democracy. In France, in Korea, CMDP, national debate, has been adopted. It's playing a very important role for Grenelle environment of France. And they are important part of the legal aspect of environment governance. And how is that handled in Germany? If you have anything to share about that, Grenelle environment in France, how that is processed in Germany. I would like to thank the organizer for inviting me to this important conference, and thank you for the opportunity. Thank you very much.
네, 감사합니다. 두 가지 질문이었는데 특별히
There were two questions, and I won't summarize them. Now, to the next discussion.
Do you want to do it? Yes, lawyer Hwang Hyun-jung. I'd like to introduce lawyer Hwang Hyun-jung. His expertise is actually environment principle, and even received PhD degree in the area of environment principle. So I am positive that he will be talking about the status of the environmental right. Would you like to start your discussion? Hello everyone, I am lawyer Hwang Hyun-jun. Well, the speakers today talk about constitutional law cases and also about environmental rights. I was able to learn a lot. Let me take a different perspective. I'd like to tell you about the future directions of the revisions of the Korean Constitution. Well, I don't know if you have any views regarding this, but if you can, please help me by giving your own views. First thing I want to talk to you about is constitutionalizations of the environmental right is necessary. As of the year 2000, as our starting point, more than 100 countries around the world has once again turned and included environmental right under the umbrella of the constitutions. But there are still countries that do not include environmental rights under the constitutions. Well, there are a lot of merits and demerits of inclusions and not inclusions. First, political circles, they are recognizing environmental rights as one of the most important value. And second, the National Assembly or legislative body will be able to come up with a new statute to protect the environment. And third, the concept of environment protections can be included within the concept of politics, and then we can come up with a new statute. So, in light of that, Korean constitutions in 1980 adopted the new constitutional environmental rights. However, under the duty of care of the Korean Constitution, it's mostly a subjective viewpoint. And as you mentioned, in case of the Germany law, there's objective law. So there are two different ways to do so. So amid these two way to do, there are merits and demerits. There's some controversy going on. In order to protect environment, especially focusing on the perspective of people, how can we pursue subjective perspective of the environmental rights? We can, in a way, strengthen the protections of the environmental right, but in terms of the ecosystems and also biodiversity or other things, in a way, we are losing the grasp of the protections of these ecosystem. Another point is that if we make the environmental right as objective as possible, then the way to implement that, the timing of that, we can actually giving more discretionary power to carry out this process. So considering the pros and cons of that, in order to maintain the current duty of care of the environmental right, we are currently trying to clarify the constitutional environmental rights of the Korean constitutions. So, if you look at the Article 5 of the Korean law, it talks about the state shall endeavor to ensure comfortable housing for all citizens throughout the housing development policies and the like. So, it also coincides.
My personal opinion is that to clarify the constitutional guarantee for environmental protection, we should have the basic environmental rights, but there could be another law introduced. But if we introduce an objective law for environmental protection, that could weaken the environmental rights, or there could be some negative aspect of this. And revising the environmental protection in Constitution should also be done in consideration for the needs of the future generation. And Korean Constitution is based on free democracy, and it is based on plurality of values and environmental state. Instead of stating this as a state objective, we should focus on sustainability in the Constitution. The second thing I would like to mention is that environmental protection through Constitution. Is it really possible to constitutionalize the principle of environmental law? As you're well aware, environmental law has the polluter pays principle of collaboration. There are traditional principles that are recognized. Such principles of environmental law are instruments to realize sustainability, and on top of that, they can be used as a standard for making decisions on individual cases. Such principles of environmental law can contradict with the causality or other principles such as police investigation, and some of the principles of environment law can contradict itself. So probably there are some limits in including this in the Constitution. Such principles of environmental law, of course, important, but sometimes constitutionalizing them might not be the best way. It might break the balance. Based on legal theory, countervailing should be considered, and things that should be heavily penalized. Some of them have been constitutionalized, and if they are considered as the upper principle, that would make the constitutional principle less predictive. One more thing before I go. The current Constitution does not clearly talk about sustainable energy system. Do we need a constitutional clause for that? According to 120 article of our Constitution has a regulation about resource development usage, but does not talk about overall energy system and eco-friendly aspect of the energy system. The Constitutional Amendment Consultation Body has said that the state should try to make the energy mix more ecological and environment friendly. I personally believe that environment friendly direction of the energy should be introduced in the Constitution. Thank you very much for your attention.
네, 변호사님 고맙습니다.
Thank you. Amazingly, you have given very compact discussion, and also you have summarized the controversy going on in Korea. Thank you. However, Professor Calless and also lawyer Roda, maybe you might believe that what lawyer Hwang Hyun-jun have said is quite familiar, so maybe we can have other discussion. Last but not least, I'd like to invite lawyer Yoon Se-jong, who is an expert in the solutions for our climate. Hello everyone, I'm from Solution for Our Climate. You know that in Sweden there's Gutenberg. In Korea we have Korean youth climate activists. Dozens of activists in Korea are very active in carrying out the youth climate actions. There are 19 environment activists who filed a suit against the government at the Korean constitutions. And this is the first time that climate change litigation has actually happened in Korea. Currently, The government and the National Assembly have not given any answers yet. We are waiting for the final answers. Through this, there are three things that we are fighting against. Let me summarize what they are looking for. They are complaining that Korean government's constitutions are too fragile, which means that it violates the rights of their life, rights of their human dignity, and rights of their fundamentals. So all of these are in violations. And also, second, this is unconstitutional because of national greenhouse gas reduction target in 2030 is actually violating because the national goal is too low and failure to achieve 2020 national greenhouse gas reduction target and also unconstitutionality of the abolition is against the law. And third, once again, we have given full delegations and full authority to the national greenhouse gas reduction target to achieve, but the government is not achieving that. And also the cases mentioned by lawyer Roda, it reminds us how important the government role is because there is Verheyen Foundations versus Kingdom of Netherlands case. And there is a duty of care and also there is this principle of excessive prohibitions principle, and we learn a lot from lawyer Roda. And also in Korea, we had this special fundamental right protections, and during the election time, there's also a public nuisance case, and we reminded ourselves this is very important. The major case is in the future whether the youth rights will be violated. What about the government? Are they taking the minimum protective actions? So regarding the first, the climate change is scientifically proven already. And in this file, we don't want any kind of controversies. That is why the IPCC reports are approved by the government of each participating country, and the government is also evaluating the current status of the climate change and the prospect for damage. Especially Netherlands and Ireland cases, if we look at those cases internationally, the climate change is well accepted as a truth. It is not something of fairy tale, but it is actually happening, and we know that. The more important thing is the government actions taken currently. Is it minimum or is it a wide range of discretionary power or what? Paris Agreement has already mentioned that in climate science and international community, the majority agree on the existence of this threat. And also the above warning can also cause a tipping point at which the Earth's climate or certain regions of the Earth change rapidly and widely. All of this will endanger the lives and welfare of the living conditions of the many people, and the the temperature is increasing by more than 3 degrees. Overall, this trend is threatening us. The carbon emissions and also per persons and also the historical roles that we are doing, because if you look at the per capita 2 times above the world average and also the rank 16th in the world for cumulative greenhouse gas emission, it proves that Korean government and National Assembly, the political circles are not taking active role. If you look at the Netherlands Verheyen Foundations versus Kingdom of Netherlands case, you can see that each country is responsible for its share. This means that countries cannot avoid their responsibility to take actions by claiming that their emissions are relatively limited compared to the rest of the world. So what do we mean by minimum doing a shares? So this can be the minimum share of the responsibility. This could be controversial. So I had one question. In case of the Germany, unlike Korea, from the EU, they have their own target by 2050, which is carbon neutrality or zero carbon emissions, and they have already set out their pathway to reduce the carbon. So the fact that EU already has 2050 carbon neutrality target, it means that you have reached the goal of complying with the IPCC. And even though in case of the Germany, you have taken this path, but depending on which methodology you are doing, you might have a different result. And in the process of that, maybe we are not protecting enough environmental right of the citizens. Once again, scientific and technological analysis is important, and fair share, how much it is, we need to analyze that. And this is technological things. So maybe we can recognize the discretionary power of the government. So I wonder what you believe, what your thoughts are on this.
Thank you for the comments. Almost the time is up, so we would have to wrap up as soon as possible. As for the questions raised, I think we can summarize them into 3 questions. First is regarding the French constitutional amendment, and when we look at the amendment in the Korean law, what is the best way to amend the Constitution? So what's your opinion about what is the best way to amend the Constitution? That's the first question. Second question is the precautionary principle. In Germany, they have accepted this principle. Do you have an example where you have actively adopted precautionary principle in Germany? And regarding the precautionary principle, it exists in European law, but not stipulated in the German law. So having this kind of principles, do you think it's the best approach to clearly mention this kind of principles? Last not least, this ban on undersizing. In order to prove the ban on undersizing, I think the discussants asked a good question. In other words, Paris Convention or any other internationally agreed greenhouse gas emission targets are not being met. But should it be seen as a violation of the ban on undersizing? I think lawyer Verheyen seems to think so. So what's your comment about that? But if there's any question from the floor, any burning comments that you must make? So Dr. Han and Professor Park, no? And Chairman Kang, no? So I would like to invite Dr. Han for his comments, and then I would like to ask the foreign speakers to comment about the 3 questions that I have asked. I'm Han Sang-eun from KIA, Professor Kali and lawyer Verheyen. So you have mentioned a lot of important things. I have one burning question. In Germany, in the state objective clause 20A of Basic Law of Germany, 20A, so lawyer Verheyen I think you said that it's the mandate of the government to achieve 2.0%. But we don't have such a consensus in Korea yet. If Germany is to have this kind of IPCC 2.0 degrees reduction as a national mandatory target, what if you fail to achieve that target? Who's going to be responsible politically? Are you going to hold somebody account for legal responsibility and political responsibility? If there is a legal responsibility, what kind of legal responsibility would they be asked to fulfill? So do you have any state objectives that has been mandated? And if somebody has failed to achieve that, what kind of responsibility or penalties, if you will, did they take? Thank you very much.
감사합니다.
I believe that both of you understood. There are many people who are joining virtually via Zoom, and they would like to pose a question. So we suddenly have one of the participants, Professor Han from Kangwon University. Would you like to say something? Can you hear me? Can we have the translation? Can you hear me? I'll be very brief. I took part virtually And I'm very pleased to see two experts from Germany. So I cannot refrain myself from asking a question. I'm dying to ask this question. Professor Calless and lawyer Roda Verheyen, thank you for your great presentation. Thank you very much. My question is as follows. EU has Climate Act. So my question is about EU's climate action. More than 40% of the carbon emission reduction was not achieved, and that is why the cases were filed. But within EU, you have heightened the target, right? From 50 to 55% of the carbon emission target was presented, and by 2050, EU is aspiring to achieve carbon neutrality or zero carbon emission, right? So you have set out the net zero carbon emission. And that is the EU Climate Act. That's what I understood. If this takes effect, that means it will give a tremendous impact to all the members. So this is not directives, but this will be a mandatory law, right? Regulation. Then I'd like to know the process. How is it going? It will be soon effective? That's my first question. And second question, what's the implication of making this as a legislation? And this is not a symbolic directive, but this is going to be a legislation, right? So which one is it going? Then the court or constitutional court, it will definitely be greatly influenced, right? Because when this climate act become a true statute, it will be heavily influenced, right? So overall, please give your views.
잘 들었습니다.
Thank you very much for the comment. I think we should invite the foreign speakers to Korea later for a seminar, but because of the limited time, I would like to hear from the two speakers. Professor Calless, would you like to go first, or Roda Verheyen? Who would like to go first?
Sorry, I don't mind. I can try, and I'm sure Professor Calless can greatly add. I'm just going to try and answer some of the questions from a practitioner's point of view. I'm not going to talk about how I think this Korean constitution could be amended. I reserve judgment on that. I really do not know enough about your system to actually do that. What I would like to talk about, however, is the question about how we could possibly strengthen the German constitution and Article 220A, also with regards to enforcement. Professor Calless is nodding, so that's apparently, yeah. I think what's happening here really is that the German constitution and also the constitutional judgments, the judgments of the Constitutional Court, they have recognized the duty to protect in a very sincere way with regard to social welfare system in Germany. And it's very clear and also in doctrinal terms accepted. What hasn't happened so far is the transition from the state duty to protect the environment and the generations to come into human rights protection, so into actual judgments and actions by the legislator. In Germany, we have a very distinct and complex system of environmental laws. We have sectoral laws, we have procedural laws, we have an incredible wealth of legal rules, but yet we are still in that dilemma of not actually keeping within the planetary boundaries. So what is missing in my mind, and this is just one area where it is missing, is the framework given by the Constitutional Court to actually say to the legislator, you're making an effort, but you're not actually meeting the objective of Article 20A within that context. And that's the climate change issue is obviously right now very, famous and everything. And the cases I'm talking about, everybody wants to talk about them all of a sudden. But there are so many other issues that we're looking at. Groundwater protection, the spread of antibiotics and very dangerous bacteria in the environment currently, which is due to insufficient regulation with respect to animal husbandry. You can point, or air pollution even, you can point to many environmental problems that are actually preventing people from living their lives as they should be able to. And I think there is a shift, that there is a shift needed to actually implement Article 20A with respect to the duty to protect. And I really sincerely hope that if the German Constitutional Court takes that step and provides the framework for this, that this will actually then also reach the legislator. And this also answers the question about enforcement. I think the constitutionalization, if that was the term, is not the issue here. I think the Constitution is here. We have a very well-functioning legal system in Germany. But what is missing is the actual translation of what's already there into the regulatory sphere. What has happened in the Berlin judgment, for example, is the clear statement by the court that, yes, climate targets can be enforced. And they will be enforced. There's already two new lawsuits arguing that the government is not enforcing the climate law itself. Even while we are discussing the validity of the climate law's targets, the government is being held by the law through the administrative law courts with respect to sectoral targets in transport mostly. So I think with respect to enforcing, we really just need standing. Currently, we have such a huge, I would even say it's a huge hurdle for us to even get anywhere close to the courts to argue the lack of implementation or the inadequacy of environmental targets. And that needs to change. So I second what Professor Calless had said, that if we could actually make some progress on the procedural parts of the environmental guarantees also in our Constitution, including on the European plane, because what we're experiencing there is also very dangerous, then that would actually make some leeway. I'm not in favor of actually spelling out the details of environmental policy in the Constitution. I don't think that would help. The other question was about the French Constitution. I would say that the French climate case, the Notre Affaires à Tout case, is currently actually challenging the boundaries of the legal principles in the French Constitution as well, and it will be very interesting to see what comes out of that case. And with respect to the status of the climate law, obviously that's something that we're all kind of looking at and working on, and I have the pleasure to actually work with some MEPs on the amendments, and it's extremely exciting to see what ended up in the actual European Parliament draft. What happens if this law is in force? I should say we would still not have an enshrinement of a credible reduction pathway unless the Parliament actually is able to secure the medium and midterm targets within it. The carbon neutrality goal is not going to actually keep us within the planetary boundaries. So the problem is not solved. Apart from the climate law not being law yet, and as you said rightly, it is a regulation. It is supposed to be an amendment to an existing regulation, which is already there in the climate governance scheme of the European Union. It would be binding on everybody, but with limited effects so far. So that's an issue that we have to really kind of keep track of. And I would like to clarify that the European Union's target for 2030 is a 40% reduction in emissions. That's the target that is at the core of the European climate case, the people's climate case, which will most likely be rejected on standing again. So we're not going to actually talk about climate change anywhere or margin of discretion anywhere in court. But the political discussion about the medium-term targets for 2030 and the adequacy of it are nowhere finished. So just to say that, yes, there will be a big influence in all of the member states, but possibly if the text isn't tight enough with respect to the reduction pathways and the medium-term targets, just stating carbon neutrality by 2050 isn't going to actually solve the problem. Yes, so I think I'll leave it there. I'm sure Professor Calless has other comments.
네, 칼리스 교수님 부탁드립니다.
Professor Calless?
Yeah, thank you very much, and thank you for your very precise and complex questions as well. Of course, we have not enough time to discuss all of them in detail because, as you have seen, maybe you have seen already with my and Ms. Verheyen presentation, that this is such a complex field between law, constitutional law, and politics. And most of your questions refer to this tension between constitutional law and politics. And this is a question, after all, of the three branches: the control of the parliament by a constitutional court, or by courts in general terms, but especially by the constitutional court. And I would like to start with that, as the German Federal Constitutional Court highlights always the responsibility of the parliament based on the principle of democracy, saying it's mainly the responsibility of the legislator, of the parliament, to decide on the conflicts between economy and environmental protection. So there is it became clear that the German Constitutional Court argues with regard to the parliament that the legislator has a wide discretion, broad discretion. But the challenge indeed is, and this is the reason why I was talking about planetary boundaries, and these are not only, as Roda Verheyen said, not only about climate protection. These are the most concrete planetary boundaries, because we have this tipping point more or less defined by 2 degrees or 1.5 degrees, something in between there. And there is an agreed planetary boundary. But we have the challenge in biodiversity as well. We have the challenge with regard to the seas, the maritime protection, and so on. So these planetary boundaries, I think these are they call for a special approach regarding constitutional law. And now the question is, to which approach? I want first to refer to the Korean constitution as far as I understood. There is, you have an environmental right, and it's using the word pleasant on the one hand and on the other healthy. And with regard to pleasant, it's really, really difficult to define what this means. So Constitutional Court would exactly say, we can't define that. This is the task of the parliament, of the legislator, to define the level of what is pleasant. But what we can define better is what is a healthy environment. Because there we can argue evidence-based, and we can argue with a precautionary principle with regard to health. This is important. We have to take into account vulnerable groups, for example, and we don't need 100% proof with regard to that. This is all acknowledged by the Constitutional Court. So there is a responsibility of the parliament, of the legislator, a duty to respect regarding the fundamental right to health. And if you argue with a duty to respect, and I would ask you not to talk about the duty to care, just use this duty to respect. This is, I think, well established by the more or less by many courts, the German Constitutional Court, the European courts, for example. Maybe it is, I don't know, sorry for that, maybe it's already used, this term as well, in constitutional law comparison by the Korean courts. But the duty to respect is quite clear. Entschuldigung, I'm not talking about the duty to respect, the duty to protect, yeah, accompanying the duty to respect, the duty to protect health. This is the approach from my point of view, for your environmental right, fundamental right in the Constitution. It's a duty to respect, and this of course, can be implemented on two ways. On the one hand, by procedural elements, I was talking about that, which is the right to information, the right to participation in environmental processes, and the right, and this is very important with regard to what Roda Verheyen said, an efficient right to access to justice. This is very important. This means there should be no narrow interpretation on the right to access to justice. This is much better because we were talking about France. The courts in France are much more open toward that. And even the European Court of Justice of the European Union is, in general terms, when it comes to the member states, more open towards such an approach. But you're smiling, whatever, because indeed, when it came to the court itself, the European Court, it's rather strict on the access to justice, something I don't understand. Yeah, and there is a lot of critique on that. But in general terms, we should accept and understand that right to health, to a healthy environment, is implemented by these three procedural elements, and part of this is broad interpreted right to access to justice. Because then people indeed have a standing to control the legislation, to control if the legislator, the parliament, is delivering, if the government is delivering on what they have promised in their legislation. And therefore, it is really important that we have now legislation, for example, on climate protection, because before it were not binding strategies, and we saw in the case at the Berlin Administrative Court, it's hard to put them under control. But if it's legal binding legislation, as a legislation, then it's legal binding, and with a broad understanding, broad interpretation of the legal standing, the access to justice, people can remind at least the government administration, you have promised in our climate law this and that, and now we want that you deliver. Because this is for a democracy a disaster. If politics the promises and disappoints people by not delivering. For 10 years in Germany and Europe, we all thought, oh, we do a lot about climate protection, but it was all promises. It was not binding. And this is the background for my argument that we have to come to more control by legal standing on the one hand, by these procedural rights, by access to justice, based on the fundamental right. And we don't need in Germany, from my point of view, because we can't deliver on that as well, a right to a clean environment does say nothing. A healthy environment we have with a together with the duty to protect, I think this approach would work if courts really take it serious. And this means the German Constitutional Court has to apply the Untermaßverbot, the ban on minimizing, or let's say the protection of this minimum level by controlling the parliament if it's really delivering, especially when it comes to that point, that the question is legislation, does it reach far enough to deliver solutions with regard to planetary boundaries? And in this context, I was referring to the expectation, and this is a very clear expectation. The court would not say to the parliament, you have to write this and that into the law, but they say, you have to achieve this objective, and you have to present a coherent, efficient plan how you want to do this, how you want to deliver on this objective. And this is something a court can control. I'm convinced about that. If there's access to justice, of course, this is an important aspect. And my other argument is with regard to the state objective. Article 28. There we need a kind of internal monitoring of the political process. And this we have, when I was in this, I was for 12 years a member of the Advisory Council of Environmental Advisory Council of the German government. And last year we wrote a report. The short summary is published in English as well. You can find it on the homepage of the Umweltrat, but I will send it as well to you, this English version. And there we thought how we can improve, not via a fundamental right, because we left this, we mentioned this discussion, we gave example, but we looked how we can improve monitoring in the decision-making process. And we were arguing that along the whole decision-making process, we need, let's say, a voice reminding, for example, in the traffic ministry, a voice, somebody in an institution, a department reminding then reminding the when legislation is defined, that somebody reminds of the political goals or the goals of the climate protection law, or let's say on the sustainability strategy or something like this. So we have to integrate institutions that are responsible for monitoring all along the decision-making process regarding legislation. So it's in Germany, it starts in the ministries, and then it comes to the parliament. And we made a lot of proposals for this monitoring in this paper. I cannot go into detail because this is another speech, and I want to not to become too long, but it's decisive to find an answer on implementation. And we have to start with a political process, the decision-making process, but as well with a fundamental right to, or the duty to protect based on the fundamental right on health. This is then a right to a healthy environment and the duty to protect. And this duty to protect implies this access to justice and would help to enforce. So we have two strings of improving implementation. Access to justice on the one hand, the right to access to justice on the one hand, by standing at courts, and on the other hand, better monitor.
Professor Calless? Professor Calless?
That was too long, but there were so many questions. I wanted to deliver kind of a framework to you, because this is then this general framework. I think this is very important to see this. So we can use, last sentence, I'm sorry, we can use the objective, the state objective 20A, and we can use fundamental rights in a procedural sense. After all, it's about monitoring and control. Yeah, thank you very much.
예, 감사합니다. 오늘
Thank you very much. I wanted to listen until the end, but we have rented this space until a certain time. We have to vacate this conference hall. I apologize for stopping you. Thank you very much for joining us. All of you, especially, I'd like to express my sincere gratitude to Professor Calless and lawyer Roda for joining us from early in the morning from your time, and also staff members. And also I'd like to express my greatest appreciation to the interpreter. Once again, today it was really a substantive meeting. This concludes the International Symposium. Thank you very much. I hope we can see you in person next time. Thank you.
Thank you very much. It was a pleasure to be with you. Thank you for the invitation. Bye.
근데 저기 다들 고생하셨으니까요. 저기 뒤에 저기 우리 모임 장소가 있습니다. 오늘 그래서 한 분도 빠지지 마시고 같이 가셔서 저녁 식사하시면 좋겠습니다. 고맙습니다.